Legal analyst Elton Hart joins us now to discuss this further. Elton, a very good afternoon to you. So, while serving as public protector, Mkhwebane, of course, was involved in numerous court battles in which, in fact, several courts criticized both her investigations and her conduct. In fact, several judgments awarded personal costs orders against her. Just how significant is this move by the South African Legal Practice Council, approaching the Gauteng High Court to advocate Mkhwebane essentially being struck from the role of advocates and, of course, citing multiple grounds?
No, indeed, it is significant because the moment you get struck off the role as an advocate, it means that you can never, ever practice until you get re-enrolled. And obviously, for her to oppose the application is then the utmost important thing to actually oppose the application, because that's her livelihood as a person that works in the legal industry. Because if you are struck off the role, it means that you cannot dispense legal advice, you cannot work in the legal industry. Yes, you can still do other jobs, but not the type of jobs that she was engaged in as a legal practitioner, be it as an attorney or an advocate. So that is something major, and obviously I don't think she's going to lie down and wait for the LPC to do it, but the LPC is basing their application on the findings of the Section 194 inquiry that was held, and based there on, they say she's biased, she was dishonest in how she conducted investigations, and hence they're actually pushing her because they feel that to be a position or to be in a position as a legal practitioner, you need to maintain higher standards of honesty and those type of things surrounding it.
And when you consider, of course, that process, that parliamentary process that we saw, and just the number of times she has been criticized by the courts, and this particular, move now, does this, the LPC also arguing that she is no longer fit and proper to hold this office. Does incompetence alone, also play a role here? To what extent does dishonesty also need to be proven?
No, obviously they look at a couple of things for them to actually bring such applications, because this is something extreme. It's an extreme measure to say that your conduct was unprofessional, you are dishonest, you are incompetent to actually do your work, and you also brought the profession into disrepute in how you actually conduct yourself, doing your work as a legal practitioner. And yes, she's raising the argument to say, but I was not on the role of practicing advocates, but you're still in that position of fulfilling that function. And especially being the head of a Chapter 9 institution, how you conduct yourself, you need to be open, honest, and transparent in how you do, because although you might not be appearing in court, but you're performing legal functions of a greater magnitude that can affect the courts. It can affect also how the Constitution is sort of half seen in a way, because you're holding this position. So it is really that what the courts would look at, and that's what the LPC is gunning for, to say you don't have these attributes, so that we can say you are a fit and proper person to be a legal practitioner in South Africa.
And how heavily will the court rely on, previous judicial findings, particularly those also that were made by the Constitutional Court? And Elton, fundamentally, could this then become a precedent, for future disciplinary action against senior public officials in this case?
It can be a precedent for senior public officials, but one needs to also now remember, as a legal practitioner, sometimes you get a judgment going against you. You're just as good as the facts that you represent. So we cannot say because a person loses a case that they now suddenly a bad lawyer. One needs to look at their conduct and specifically look at how they conducted themselves in a transparent, open, accountable manner, and dishonesty, and also your conduct as to how you behave towards judgments that is given against you. Are you going and attacking the judiciary? Are you actually just appealing your judgment? So just because she lost some of the cases and some of the judgments was against her is not an overwhelming thing, but there's some of them where the courts actually say, and they actually spoke to the manner in which she conducted some of the investigation, it leaves a lot to be desired. And I think there is the ones that we can. And obviously with holding government officials or Chapter 9 heads sort of half accountable, I mean, this was established already by the Black Sash case. It's coming thick and fast. It's just now giving these personal cost orders against them and no longer the taxpayers' dime to actually pay for their misconduct, if one can use the word loosely.
Yeah, and conversely speaking, if the court declines to strike her off, what precedent then could that set?
No, I think obviously if the court makes a decision and the court says, okay, LPC, we do not agree with you that conduct amounts to incompetence, dishonesty, and her behavior was not such grave or gross irregular behavior that it cannot be remedied with a different punitive sanction, then the courts can most probably say, but obviously the LPC then has the right to say, okay, the High Court made this decision, we are not happy, we're going to appeal the decision because maybe they did not look at X, Y, and Z. So there's always that situation. And if they also come to a point where they say, but your conduct was as untoward, it's dishonest, it's not becoming of a legal practitioner, and she gets struck off, she can then also follow the route to actually appeal whatever decision is taken by the court.
Yeah. When you also look at, just some of the grounds of the LPC, at its core, is this case really about Advocate Mkhwebane or fundamentally about protecting public confidence in, the legal profession and the integrity of the country's constitutional institutions?
And now one needs to really look at who is actually the drivers of the application, and one needs to go look at if it's the LPC, who's the drivers of the application, and what complaints was received from members of the LPC. And if there's a couple of bodies that's affiliated to the LPC, like your bar associations, your different bar associations, that they say that her behavior was unbecoming of an advocate, they're not happy with it, and they want the LPC as the overarching body to actually act on behalf of advocates because they are concerned and they want this thing to be taken further, then the LPC will have to take it further, because here you have got members that's members of you, and they're raising a concern to say that this person brought the profession into disrepute and you should act. And that is how the LPC would normally have to view it, to say, okay, who was the drivers behind the complaint, and obviously looking also, is there merit to the complaint before they can actually take such a drastic step. And I don't think the LPC would have taken this decision lightly to actually bring an application to remove her from the role.
Very interesting. Thank you so much, Elton, for your time and, of course, your analysis. Legal analyst Elton Hart just weighing in on this particular matter.